Good afternoon and welcome everybody. Brad Bestgen with Bestgen Wealth Management. Excited, actually super excited today to bring you another topic in our latest educational video series. And we're piggybacking on what we talked about in our last video regarding the importance of estate planning, because there's been some new laws, some new bills that were enacted late in December 2019 that went into effect January 1st, 2020. Most notably the Secure Act, or Setting Every Community Up for Retirement Enhancement. That is a lot of features, a lot of benefits. I'm going to do a two-part video series getting into all of them. Today I want to talk about the one that mostly closely impacts estate planning, beneficiary designations, charitable gifting, a lot of topics that are important to a lot of people. And this is the type of stuff that gets us excited. It's one of the reasons I love what I do, because things are changing all the time and always got to be on the forefront of it to be able to help your clients when they need it. So without further ado, if you're not familiar, there's a commonly used financial planning technique that used to be called a stretch IRA, which would allow multiple generations to inherit retirement assets, take out minimum required distributions over their life expectancies, and keep those assets growing on a tax-deferred basis inside those retirement vehicles. Well, after the Secure Act, that law has now changed. They created what is called eligible designated beneficiaries. And if you are not one of these designated beneficiaries, that stretch allowance no longer is eligible for you. So if you are not on this list and you inherit an IRA, a 401k, a 403b, you have to distribute all those assets within 10 years of receiving them. So there's no annual requirement like current required minimum distributions, but all the money has to be out of the account by the end of the 10th year. So you could essentially inherit it, leave it for 9 years, and the 10th year distribute everything. But if that's coming out of a 401k and IRA, that's a lot of taxable income to you in 1 year, which you're most likely going to want to avoid. And so back to these designated beneficiaries, who are they? Most notably, one is a spouse. So you name your spouse as a beneficiary. Second is a minor child of that original IRA owner. Can't just be any minor child like a niece or a nephew, it has to be your child. Second is a disabled person. 3 is a chronically ill person, and 4 is a beneficiary that's no more than 10 years younger than the current IRA owner. So if you don't fall into those categories, as I mentioned, you can no longer stretch out that distribution. For example, under old rules, if I inherit an IRA from my grandfather, I'm 40, I have almost a 45-year life expectancy. I could take small minimal distributions each year and stretch that IRA over the next 45 years. If there's money left, I could leave it to my wife, to my kids. It could continue to stretch. Now, in 2020, if I inherit that, I have to take all that money out within 10 years and it's gone. So one of the key things to note that I didn't mention as that group is trust. A lot of people name trusts as beneficiaries of IRAs. Now, there's multiple different types of trusts. Some, depending on the language, are still going to qualify for that stretch. Others, unfortunately, are not. So you want to make sure you talk to your estate planning attorney and talk to your advisors. Make sure your beneficiary designations are correct the way you want them to be under the new law. Make sure if you named a trust, either it's a primary or a contingent beneficiary, the language in the trust is still going to hold up under the new laws and have your money going to the places you want when they want that you originally intended when you drew up the plan. So the good news is there's planning that you can do to help mitigate some of these tax concerns, mitigate the estate planning concerns. Things such as Roth conversions, are those appropriate for your family? Charitable gifting out of your retirement accounts during your lifetime. Naming a charitable remainder trust as a beneficiary on an account. Potentially using life insurance, an irrevocable life insurance trust to help mitigate taxes at your passing. So there's a lot of things you can do. The bottom line is be aware, make sure you're up to date on your plans, your beneficiaries, what you want, when you want it. Talk to your advisors, get it done, get it straightened out, and I'll come to you with another video talking about more benefits of the Secure Act in our next video, both for individuals and for business owners. Thanks for tuning in. Make it a great day. Thanks again.